If we think civilians could be tried, this is the proposal. Recruit and train all Ugandans into the military. Arm them with all the items that are a monopoly of the UPDF. And then introduce a law which would then allow every Ugandan to be tried in the courts martial. There, we would have known the guidance of what you should do or not to do in the army. So that when all Ugandans are soldiers and are army, you can then try them. Without prejudice, Madam Speaker, to the recommendations proposed above, should Parliament insist on proceeding on the bill, the minority shall propose amendments to clauses 29, 30, 31, 35, 38, 45, 57, 63, and Schedules 7A and B. Right Honourable Speaker, it is trusted that this Parliament is appointed for the welfare of society and the just government of humanity. And we, the servants who are here assembled right now, are being looked upon with abundant flavor to perform such an important trust of Ugandans. Do not betray that trust. This morning, I made a phone call to the chairman of Legal and Parliamentary Affairs Committee, and I told him on the phone that I have a minority and the chair is here. Secondly, when I reached Parliament, I again notified him on our platform, and then I filed this report with the clerk of our committee, who duly submitted to the clerk to Parliament. It has been duly stamped as received. So the record should show that I am not smuggling, I'm just complying with the rules. Madam Speaker, before I read, I beg these two situations for members to bear with me. First of all, as Honorable Ochero rightly observed, the leader of the opposition, my boss, has led a walkout from this city, and I am his shadow minister for justice and constitutional affairs. You can imagine the situation I'll be. I may finish and I get fired. So allow me present this report here. Secondly, in tense moments like this, you would beg that members bear with me. During the ruling in the Supreme Court, at myself and many others against the Attorney General, when their lordships had judged 3 against 3, the last judgment was by the Chief Justice then, Bart Katurebe, and when he had begun to read, he informed us that his glasses and the eyes had a problem, and he needed to be rushed to South Africa immediately. I pray when I'm reading this report, my glasses don't fail me. Having said that, Madam Speaker, introduction. This is a minority report in dissent of the majority report of the Joint Committee of Legal and Parliamentary Affairs and the Committee of Defense and Internal Affairs on the Uganda People's Defense Force Amendment Bill 2025. This minority report is brought under Rule 215 of the Rules of Procedure of Parliament, areas of dissent and statement of reasons for dissent. The minority restricts the areas of dissent majorly on the policy and principles, defects in the existing law, remedies proposed in the bill, and specific provisions of the Uganda People's Defense Forces Amendment Bill 2025, touching the courts martial and related matters, including the schedules. Approach. In this minority report, it presents specific thematic areas of dissent, the reasons for the dissent, and explanatory statements for the reasons of dissent, and this minority report is guided by the provisions of the 1995 Constitution of the Republic of Uganda, the applicable subsidiary legislations, and the lead judgment in the Supreme Case, Attorney General versus Michael A. Kabaziguruka, Constitutional Appeal number 2 of 2021. Therefore, Right Honorable Speaker, each word, sentence, paragraph in this report has been carefully considered by the minority for justifying the dissent from the main report of the committee, the minority prays that time be allowed for this report to be presented to the House, both verbatim and seriatim. Thank you. Preliminary and substantive discussions on points of law. In this report, the minority raises several points of law in both preliminary and substantive forms. The minority submits that meaningful debates and decisions of Parliament can only take place after the presiding officer has disposed of, by way of a formal ruling, with reasons, all the points of law raised. The presiding officer should not be tempted to sweep under the carpet, fail, or casually dismiss these important issues of points of law raised by the minority. In short, the minority invites the full attention of the presiding officer during the presentation of this report and prays for the rulings to be delivered on record in a timely manner before debate ensues. Breach of Rule 75 of the Rules of Procedure of Parliament on subjudice. During the consideration of the bill, the Uganda Law Society brought to the attention of the committee and Parliament an active court case in the East African Court of Justice, which court decisions are binding on Uganda, as set out in the landmark precedent case of Among A. Anita versus Attorney General of Uganda, and another, reference number 6 of 2012. I produced the letter dated 14th May 2025, and it is addressed to the clerk to Parliament and reads as follows. Reference, the Uganda People's Defense Amendment Bill 2025. Greetings from the Council, management, and staff of Uganda Law Society. In response to your invitation to meet the Joint Committee on Defense and Internal Affairs and Legal and Parliamentary Affairs for consideration of the above captioned bill, for which we are grateful, this is to inform the Joint Committee as follows. 1. The Uganda Law Society received your invitation letter today at 11:50 a.m., scheduling a meeting for 12 p.m. on the same day. With the greatest respect, the time frame is manifestly inadequate for a thorough consideration of the 150-page bill and is incompatible with democratic accountability. 2, be that as it may, the Uganda Law Society hereby brings to your attention reference number 14 of 2025, Uganda Law Society versus the Attorney General of the Republic of Uganda, pending before the East African Court of Justice. Discussing the bill's provision on military courts would inevitably breach the subjudice rule, contrary to Rule 75 of the Rules of Procedure of Parliament of Uganda, Statutory Instrument number 43 of 2025, and Article 38, Sub-Article 2 of the Treaty for Establishment of the East African Community, and potentially contravenes Articles 2, 20, 79.3, 92, 126.1, 128.3, and 287 of the Constitution of the Republic of Uganda. 3. Given the pending litigation, we respectfully request the Joint Committee to urge government to pursue amicable resolution of the dispute before engaging Parliament and on the contested matters. The Uganda Law Society welcomes the opportunity of another invitation to discuss the rest of the bill. Yours, it is signed by Ewan Asimwe Anthony, who is the Vice President of Uganda Law Society. I don't know for what reason why the President was not available to sign. I now beg to lay on table the copy of duly received by the Office of the Clerk, as well as a copy of the reference number 14 of 2025, Uganda Law Society versus the Attorney General of the Republic of Uganda. Madam Speaker, this document is already part of the minutes laid by the committee. If it's not there, I have a copy that I can lay. In the same vein, the minority also draws to the attention of the Right Honorable Speaker of Parliament and Parliament the constitutional application number 01 of 2025 Male Mabirizi K. Kiwanoka versus the Attorney General, filed in the Supreme Court of Uganda on 14 April 2025. And the same has been duly served upon the respondent who is present in this sitting. The gist of that application is that the Supreme Court should determine whether the action of the respondent, who is the Attorney General and government and parliament, of proposing and consideration of the Uganda People's Defense Forces Amendment Bill 2025, providing for trials of civilians in the court-martial, is contemptuous of the judgment of the Supreme Court in Uganda, in Supreme Court of Uganda in Attorney General versus Michael, which I have already cited fully. The constitutional application number 01 of 2025, as referred, filed in the Supreme Court, has already been duly served. The respondent, the Attorney General, is present in this House and can confirm or deny the existence of this live case. All that the minority is belaboring by this submission is to demonstrate by all standards that there is a live and active dispute, not only before the East African Court of Justice, but also Uganda's highest court, the Supreme Court. It will be quite embarrassing for Parliament, an institution central to democracy and the rule of law, to carry on with the consideration of the Uganda People's Defense Forces Amendment Bill 2025, well aware of the court cases that touch on the subject matter of the clauses in the bill. The finding of the minority. The minority finds that Parliament proceeding to consider the clauses of the UPDF Amendment Bill 2025 touching the subject matter of trial of civilians in the court-martial undermines the core tenets of the rule of law, the doctrine of mutual respect for separation of powers between the executive, legislature, and judiciary. The next is on retrospectivity of legislation, contrary to Article 92 of the Constitution of Uganda. Article 92 of the Constitution of the Republic of Uganda on restriction on retrospective legislation states as follows. Parliament shall not pass any law to alter the decisions or judgments of any court as between the parties to the decision or judgment. Decisions or judgments of courts are categorized into two, one in personam and two in rem, to mean against a person and the world at large. In the considered opinion of the minority, that judgment in Constitutional Appeal number 2 of 2021, Attorney General versus Michael K. is firmly binding on the movers of the bill as well as this Parliament. In short, unless Parliament is deliberately and with utmost impunity dismissive of the judgment of the Supreme Court of Uganda, which judgment was led by none other than Honorable the Chief Justice of Uganda, Alphonse C. Owindolo, together with his brother and sister lordships of the Supreme Court, the Honorable Lady Justice Catherine Bamugemerere, the Honorable Lady Justice Monica Kalejera Mugenyi, the Honorable Lady Justice Faith Mwanda, the Honorable Lady Justice Elizabeth Musoke, the Honorable Lady Justice Percy Knight Tuhaise, and the Honorable Justice Mike J. Chibita, who did an splendid job. And I invite members who are still active that when you get children, you can name them after these lordships. And those who cannot get children, when the technology-assisted reproductive law comes in force, you can produce using and name them. One of the best indicators of a progressive democracy is respect for the rule of law, which includes respect for judgments of courts. If this Parliament, in the full glare of right-thinking Ugandans and the entire world, proceeds to disobey the Supreme Court, then this day, date, and year will go down as the official birthday of the dreaded military dictatorship in Uganda. We surely don't wish to be the midwives to deliver this baby at all. Madam Speaker, let it also sink in our minds that at any one point soon in our lifetime, Uganda will have another president other than H.E. Museveni. The next president, as per the law, shall be the commander-in-chief, boss of the court-martial. This House may have already noticed the following names, in no particular order of chances of being the president, being discussed in the public domain as potential future presidents starting in 2026 and beyond. The Honorable Akena Jimmy James Michael Obote, the Honorable Chagulanyi Sentamu Robert, the Honorable Amuriat Patrick Oboy, General Kainorugaba Muhozi, General Mugisha Muntu, Honorable Norbert Mao, Right Honorable Anita Among, Colonel Retired Dr. Kiza Warren Besige.
Honorable, I've never wished to be a president. Remove my name from that list. I am satisfied with what I have, and I'm even getting out of politics. Don't put my name into this.
Madam Speaker.
No, my name is not for playing. My name is not for jokes.
Madam Speaker, allow me, since it's a one.
Please, my name is not for jokes. I never want.
Yes, I'm coming.
Honorable, it is my name.
Madam Speaker.
Please remove it.
Yes, this is a one member's report signed by me, and I can amend it. I want to withdraw. That's what the point I want to make.
Yeah, withdraw. I'm not part of that.
That although I had said that the names were in the public domain,
public domain.
I beg to withdraw.
I have my own right.
I beg to withdraw and delete and amend this report by deleting the name Right Honorable Anita Among Annette from this report. And I accordingly withdraw and apologize to you, Madam Speaker. Please, the records has it. Please, I invite this House to carefully reflect on each one of them, their soberness, fidelity to the law, ideologies, actions, sentiments, service records, and imagine what each one of them is capable of using such provisions in the bill. The finding. The minority finds that legislating on clauses of the bill that touch on the decision of the Supreme Court, specifically enacting clauses to try civilians and soldiers who commit civilian crimes in the courts martial, contravenes Article 92 of the Constitution of the Republic of Uganda in light of the case of the Attorney General versus Michael K. Constitutional Appeal number 2 of 2021. The next point is dissent is understanding of the judgment of the Supreme Court in that case. Right Honorable Speaker, during the consideration of the bill in the committee, an issue arose as to whether there was a lead judgment to inform the consideration of the bill, or all judgments of the quorum mattered. The learned Attorney General informed the committee that the judgment of Honorable the Chief Justice, as is the lead judgment, whose final orders and recommendations guided the drafting of the bill. Whereas the minority considered the other judgments as equally important, in as far as several rulings therein, the minority, for purpose of harmony, agreed with the Attorney General to restrict discussions around the lead judgment of Honorable the Chief Justice, Alphonse C. Owindolo, who listed 6 specific issues that the Supreme Court was required to resolve, and the issues are as follows. The first was whether the court-martial are courts established under the Constitution or are mere tribunals. 2, whether the court-martial can be or are independent and impartial within the meaning of Article 28 of the Constitution. Whether civilians can legally be liable to face trial in the court-martial for disciplinary offenses, herein called military, disciplinary, or service offenses, stipulated in Part 6 of the UPDF Act. 4, whether civilians can constitutionally or legally be tried in the courts-martial for civil offenses not comprised in Part 6 of the UPDF Act, but are instead provided for in other legislation. 5, whether it is constitutional for persons subject to military law to be tried in the court-martial for offenses outside the UPDF Act, herein called civil offenses. 6, whether it is constitutional for civilians to be tried by the court-martial as principal for offenses under sections 1191H of the UPDF Act. Yet all those also exist in the civilian offenses. Right Honorable Speaker, the minority has found it necessary to briefly highlight the decision of the Supreme Court in each of the questions, as this will be extremely important. First, in refreshing the memory of the members. Then secondly, and most importantly, guiding the members to properly direct their minds during the debate on the principles and justification of the bill. On the first issue, number 1, whether court-martials are courts established under the Constitution or a mere tribunal. In answering this question, Right Honorable Speaker, which answer was agreeable to the rest of the panel, Honorable the Chief Justice Alphonse C. Owindolo wrote on page 44, paragraph 15 as follows: I would therefore hold the General Court-Martial is not merely a complementary court to civil courts. It is established as a court which is, however, seized with specialized jurisdiction. The take-home from this answer is therefore twofold. One is that the Supreme Court recognized the existence of court-martial as a creature of law. And secondly, but most importantly, its special status, implying it is meant for specialized cases only. I now quote the learned Attorney General of Uganda in a letter which I also beg to lay, I believe is part of the documents laid, written on the 3rd February 2025, addressed to the Honorable Minister of Defense, addressed to the following: Honorable Minister of Defense, the Chief of Defense Forces, the Chief of Joint Staff, and Director of Public Prosecutions, in paragraph 2 on page 2 and paragraph 9 on page 3, reproduced below. This, I quote what the Attorney General wrote. Section 197, now Section 195 of the UPDF Act, which establishes the General Court-Martial, is duly established under the law as a competent court, is constitutional. The Attorney General said, our understanding of the above declaration is that the General Court-Martial is duly established under the law, and its existence is consistent with the Constitution. However, it must be clothed with the following attributes. A, members of the General Court-Martial must be persons with requisite legal qualifications. B, the members of the General Court-Martial should be independent of the command and have security of tenure. C, there should be adequate time and facilitation in the preparation of defense by an accused person, as well as a right of an accused person to due process and an appeal in capital offenses. D, the convening authority must lie with the General Court-Martial, which guarantees institutional independence from the authority prosecuting the case. This is what the Attorney General advised, and it will help us when we come to closes. Attorney General further writes, Sections 2, 179, 1191, H and G, now respectively 177, 10X, 1171H and G of the UPDF Act are unconstitutional, since they confer blanket jurisdiction on court-martials to try civilians. Our understanding, this is what the Attorney General wrote, our understanding, the understanding of the Attorney General of this declaration 7, 8, and 9 by the court is that civilians cannot be tried in military courts. Our understanding of these declarations 7, 8, and 9 by the court is that civilians cannot be tried by military courts. I quote from the Attorney General. The minority recognizes the mandate of the Office of the Attorney General under Article 1193 and 4 of the Constitution of the Republic of Uganda, to wit, shall be the principal legal advisor of government and to give legal advice and legal services to government on any subject. It may be recalled, Right Honorable Speaker, that in both the original constitutional petition, number 45 of 2016, Honorable Michael A. Kabaziguruka versus the Attorney General in the Constitutional Court, and in the Constitutional Appeal, number 2 of 2021, the Attorney General versus Honorable Michael K. The Attorney General diligently and professionally offered legal services representation in court and lost all the arguments except the legality of existence and creation of the court-martial. However, how then does the executive and even parliament expect the same learned Attorney General to again go back to the Constitutional Court and Supreme Court to defend the same issues which he argued and lost? It must be very burdensome, tiresome, hopeless, and frustrating to be a lawyer to the government in such scenarios. Sympathies to the learned Attorney General, Honorable Kiwanuka, and the team of learned friends in the chambers of the Attorney General who prosecuted the case. Can they even dare face the same court again on the same issues already decided by court? Finding. And I must say, on a lighter note, Madam Speaker, a former Attorney General William, Senior Counsel William Biarohanga, I'm reliably informed, asked to be excused from executing the role of Attorney General. Then another Deputy Attorney General who was with us here, Honorable Mwesiga Rukutana, immediately he left this role. He had the energy to marry even a new young wife. So it is really burdensome to be an Attorney General.
Honorable Odur, you're going personal. Please.
I withdraw.
She has nothing. I mean, what's wrong with marrying a wife?
Finding.
Huh?
I withdraw, Madam Speaker. Finding. The minority, therefore, finds that there is no legal basis to provide for trial of civilians in the military court as decided by the two highest courts of Uganda, Constitutional Court and the Supreme Court. The minority further finds that there is no political, ideological, and security narration to justify enactment to provide for trial of non-military offenses in the court-martial, and therefore is shallow, unreasonable, and unconstitutional. Court-martials, as found by the Supreme Court, are established legally, hence there is no need to re-establish it. Court-martials, as found by the Supreme Court, and this is what I want members to pay attention to, are already established legally, hence there is no need to re-establish it. The question of restructuring of the court-martial is necessary, but as shall be later pointed out, not possible through provisions of the proposed bill. Subordination of the court-martial. That's the next point of dissent. The Honorable the Chief Justice, Alphonse C. Owindolo, in his judgment, found as quoted below. Additionally, I open the quote, additionally, as already noted, the General Court-Martial and other military courts are all subordinate courts. See the case of Attorney General versus Uganda Law Society, Constitutional Appeal, number 1 of 2006. However, I do not agree with Mulenga, Justice of the Supreme Court's finding, where he held that the General Court-Martial is subordinate, but not lower than the High Court. According to the Black Laws Dictionary, Brian A. Garner, 8th edition, subordinate means placement in or belonging to a lower rank, class or position, or subject to another's authority or control. Assigning the ordinary English meaning to the word subordinate, all courts-martials are subordinate courts created under Article 129, 1, sub-article D, and can only have jurisdiction that is lower than the High Court. Saying that it is subordinate but not lower than the High Court is contradictory and has potential to create an absurdity when it comes to hearing of capital offenses. If Parliament desires to grant them jurisdiction to handle capital offenses, then it would need to do so in line with the Constitution. The minority observes, Madam Speaker, that Article 129 of the Constitution of the Republic of Uganda provides for the courts of judicature as stated in the judgment. Article 129.1, the judicial power of Uganda shall be exercised by the courts of judicature, which shall consist of A, the Supreme Court of Uganda, B, the Court of Appeal of Uganda, C, the High Court of Uganda, and D, which is underlined, such subordinate courts as Parliament may by law establish, including the Cadi's Court for marriage, divorce, inheritance of property, guardianship, as may be prescribed by Parliament. Article 129 of the Constitution is on the jurisdiction of the High Court and states as follows, and we can read together. 1. The High Court shall, subject to the provisions of this Constitution, have unlimited original jurisdiction on all matters and such appellant and other jurisdictions as may be conferred on by this Constitution or other law. In light of the judgment of the Supreme Court, Madam Speaker, any court created by Parliament is inherently subordinate to the High Court. Any court created by this Parliament, whether we go ahead and create or not, is inherently, by this provision of the Constitution, subordinate. We cannot create a court equal or higher. For any court to be created with either the same or higher jurisdiction to the High Court, it has to be directly created in the Constitution under Article 129, Sub-Article 1, and listed either in, you can reflect, in Clause 1C with the High Court, meaning at the same level, or immediately before Clause 1D to exclude it from the subordination. The minority also observes further that conferring unlimited jurisdiction on courts created under Article 129, other courts other than the three courts of record. The minority also observes further that conferring unlimited jurisdiction on courts created under Article 129D, which we are about to do, of the Constitution is equivalent to amending Article 139, Sub-Article 1 of the Constitution, to the extent of creating exceptions limiting the already unlimited original jurisdiction conferred by the Constitution of the High Court. I can repeat that. The minority observes further that conferring unlimited original jurisdiction on courts created under Article 129D, such as the court-martial of the Constitution, is equivalent to amending by infection Article 139(1) of the Constitution to the extent of creating exceptions limiting the already unlimited original jurisdiction conferred by the Constitution on the High Court. Is it therefore allowed to amend the Constitution through an amendment of an Act of Parliament? The obvious answer is no. The Constitution can only be amended in conformity to Chapter 18, Articles 259 to 263 of the Constitution of the Republic of Uganda. The minority submits that the UPDF Amendment Bill 2025 is not a bill for an act to amend the Constitution, and therefore cannot attempt by trickery or any other means, including fraud, purport to amend Article 139 of the Constitution of the Republic of Uganda. Right Honorable Speaker, the advisory order recommendations of the Supreme Court are stated in paragraph 10 on page 199, bullet E of the judgment of the Honorable, the Chief Justice Alphonse C. Owindol as follows. E, amend the Constitution, and pay attention, this is what the Chief Justice ordered or recommended. Amend the Constitution to establish superior courts within the military court system under Article 129, and clothe those courts created by amendment of the Constitution with the requisite jurisdiction and guarantee of independence and impartiality to try specific military offenses under existing laws committed by military personnel. F, the Chief Justice advised, provide in the UPDF Act for the High Court, which is already created and in existence, to sit as a court-martial with power to try all criminal capital offenses within the High Court's jurisdiction, and those unique to the military that attract maximum of life and death sentences. Grant the Chief Justice powers to assign judges to the military courts. A select number of military personnel can therefore act as assessors. Appeals to the court-martial appeals court would follow the same format, with Court of Appeal sitting as such. Magistrates' courts would assume the jurisdictions all over other offenses of a subordinate court. G, the Chief Justice says, make provisions in the UPDF Act for trials of civilian in the military courts to be only under limited circumstances and only after the state concretely demonstrates to the court by verifiable facts and by objective and serious reasons the need and justifications for recourse to the military courts. This must only apply where, in relation to the specific class or category of persons, offenses in question, ordinary courts are not in position to undertake. This is the quote of the Chief Justice upon which this bill has been brought. The understanding of the minority on these advisory orders E to F and G above is that they are premised on the fact that all trials of both civilians and military personnel who commit non-service stroke military offenses must be before civilian courts. In other words, the current civilian courts, Magistrates Court, High Court, Court of Appeal, and Supreme Court are all competent by all standards required under Article 28 and 44 of the Constitution of the Republic of Uganda to try any offense in the law books of Uganda. A question was put to the learned Attorney General on whether his trust, confidence, and belief, a question was put to the Attorney General on where his trust, confidence, and belief would lie in delivery of justice on the offenses proposed in the bill. Were those trials to take place premised on the same facts before either the civilian courts or the court-martial? So we have two sets of same offenses. Which of the two courts would the Attorney General trust? The learned Attorney General answered that both courts can and would deliver justice. The understanding of the minority on this answer is that the learned Attorney General confirmed that civilian courts in existence right now is capable of conducting any trial of criminal nature in Uganda without need to waste time and resources on the court-martial, which has unconstitutional structure. The structure, not the court-martial. The court-martial is constitutional, but its structure has unconstitutional structure, incapable of delivering a free, fair, and impartial justice to any accused person. Even, Madam Speaker, even if this answer is denied, the question to the government and the mover of the bill is the government of NRM in power for 39 years and who virtually recruited and appointed all the cadres, the investigators, the police, the prosecutors, office of the DPP, the arbitrators, the judicial officers, if we check on the record of the current structure of police, leaderships, and the rest, all of them have been recruited by this government. Are they therefore justified to complain on the incompetence, the weakness in the judicial system? The question is, the NRM government in power for 39 years and who recruited and appointed all the cadres in the justice system, the police, prosecutors, and the arbitrators, the judicial officers, are they justified to complain on the incompetence, weakness in the civil courts to handle any case in Uganda? If the minority was granted more time, Right Honorable Speaker, it would have produced on record all cases of murder, aggravated robberies, terrorism proposed in the bill against accused persons, including military personnel, which has been successfully prosecuted in the civilian courts. By the time of writing this report, Madam Speaker, I had not known that yesterday the High Court convicted a former soldier, a militant, of an offense. That further demonstrates and strengthens my argument that actually the civilian courts right now can try and convict, murder, aggravated robbery, etc. The minority invites the attention of members, especially those familiar with court papers, to reflect on the proposal of the Chief Justice, which captures the spirit of the advisory orders by the Chief Justice as follows. I have put a heading there just to illustrate when we come to the amendment. All the headings of courts in Uganda would be written the Republic of Uganda. In the High Court of Uganda, it could be in Kampala, the example, and in bracket, we put the provision for court-martial stroke military division. That is what the learned Chief Justice had advised. Finding, the minority finds that the proposals in the Uganda People's Defense Forces Amendment, Bill 2025, purporting to recreate the court-martial with unlimited original jurisdiction is unconstitutional, as it inadvertently amends Article 139 of the Constitution of Uganda without following the procedure of amendment provided under Chapter 18 of the same Constitution. The minority further finds that it is administratively viable to provide for a specialized court within the civilian courts for purpose of trial of criminal offenses committed by the military person. The next point of the dissent is on limited or exceptional circumstances, as it has been said. Madam Speaker, the minority recognizes the discussion in the judgment on the limited circumstances of trials of civilians and or military persons in the court-martial in Uganda. In the judgment, the minority understands that these circumstances appear to be strictly in reference to a situation where, and we can pay attention, one, the Constitution is not in force, similar to the military rule during Idi Amin's regime. That is the first condition for trial of civilians in the military court. There must not be constitution in force. Two, courts of law have no capacity to try the offenses. For example, there are shortages of competent judicial officers. Three, soldiers and civilians are on duty or deployed in a foreign land where there is no possibility of returning them for trial in Uganda, and there is no other court in that country to try the accused. We all know where our army, the UPDF, are deployed, so the court-martials can try them there in case that country does not have a law or the situation of the war in that country. That is the understanding of the minority. The scenario of Karamoja, which was presented in the committee as a success story of the court-martials, was unjustified. It was claimed that judicial officers had feared to be deployed in Karamoja to hear cases because of insecurity. These are the questions. Were other courts in the neighboring districts also unavailable to try those cases? Did the same government demonstrate to Ugandans that courts in Karamoja were fully functional when Colonel retired Dr. Kiza Besigye was flown to Moroto and charged in the civilian courts? Who is mandated to ensure law and order in Uganda? And why not deal with the root causes of it all, which is the security of the judicial officers, rather than recourse to the courts-martial? Madam Speaker, were the trials free and fair in Karamoja? The presumption of innocence, the charge sheets, were they read through them? Did they take proper plea? Did they give evidence as per the Evidence Act? Was there a ruling on the prima facie case? Was there a defense? Were there the convictions? Did they allow them to plead to mitigate? And what was the sentencing guideline? In the opinion of the minority, it is foolish to legislate to provide for unconstitutional situations, like providing for scenarios where the constitution laws are not enforced. All I am saying, Parliament cannot sit and legislate for a situation where the constitution is not. It would be foolish of us to do that. And as such, to make...
At least not everybody is foolish.
No, I just said it is. I didn't accuse anybody. Right, Honorable Speaker, to make all Ugandans liable for trial in the military justice system. First, all Ugandans... Madam Speaker, to make all Ugandans liable for trial in the military justice system, first of all Ugandans must become militants and officers with proper officers. That first, let's provide for a law for all Ugandans to become militants and officers with proper training in aspect of militarism, with each one of the Ugandans being formally passed out by the commander-in-chief, and we are kept, all of us, as the reserve force. The laws of Uganda can then be amended accordingly to provide a concrete basis for such an arrangement. The minority is saying that once all Ugandans are militants, then it is possible to provide for court-martial so that we are all trained and we know we are soldiers. The finding. The minority finds that there are no limited or exceptional circumstances existing in Uganda at the moment, as the constitutional framework and other legislations are in force, and they are adequate to deal with all criminal matters before the civilian courts. The minority further finds that military disciplinary offenses, as provided in Part 6 of the Principal Act, can be exclusively tried in the court-martial or other disciplinary mechanisms within the command structure of the UPDF. On issue number 2, on whether the court-martial can be or are independent and impartial within the meaning of Article 28(1) of the Constitution. The answer to this, which the other 6 land justices agreed to, some, albeit with different discussions, is found in paragraph 20 on page 117 of the judgment of Honorable the Chief Justice Alphonse C. Owendolo, whose conclusion is reproduced below. I open the quote. Having regard to what I have discussed above, on the issue in the light of the rights to a fair trial enshrined in our Constitution, I find that the safeguards for independence and impartiality of the military court system in Uganda and their procedures for trial do not guarantee a fair trial. It is evident that the General Court-Martial lacks the independence and impartiality required under the Constitution for it to subject the respondent to a fair trial. The observation right therein falls short of the findings of the Supreme Court, as there are no procedures for trial. Is it safe? The observation of the minority is that the principles of the bill and the provisions therein fall short of the findings of the Supreme Court, as there are no procedures for trial. When we go to the clauses, I will be asking questions for these procedures to be demonstrated to you. No safeguards for independence and impartiality of the proposed court-martial, which can guarantee the fair trial envisaged by their lordship. On issues 3 to 6, which are summarized here, as to whether civilians can be tried in the court-martial for any offense, and whether soldiers who commit civilian offenses, murder, terrorism, aggravated robbery, cattle rustling, misprision of treason, kidnap with intent to murder. The answer, Right Honorable Speaker, to questions 3 to 6 is found on paragraph 10, pages 142 and 145 of the judgment of Honorable the Chief Justice Alphonse C. Owindolo, who wrote, I open the quote, "The general rule is that ordinary courts alone have jurisdiction to try civilians. I am unable to find any rational or justifiable link between the need to maintain discipline in the army or the maintenance of security of Ugandan borders and the trial of civilians in the military tribunals generally. This position is bolstered further in the light of my finding that trials in the court-martial are devoid of independence, fairness, and impartiality in the conduct of proceedings therein, and the reasons given by the various commissions referred to that discourage trial of civilians by military courts. The result of my finding is that a case where a civilian and a military personnel have committed a crime, both should be tried in the civilian courts. When we go into the clauses, I'll be seeking to see how this is provided for. In conclusion, this is what the Chief Justice wrote. The provisions for the blanket trial of civilians in the military courts either as principles in section 1171H or as accomplices in sections 1171G does not satisfy the limited or the exceptional requirements of Article 41 of the Constitution. They are unconstitutional. Right Honorable Speaker, the offenses provided in the bill, murder, aggravated robbery, kidnap with intent to murder, treason, misprision of treason, and cattle rustling have all been provided already in our law books. That is the Penal Code Act. The other offenses in the different pieces of legislation, including traffic offenses, pay attention. The other offenses in the different pieces of legislation in Uganda, including traffic offenses, electoral offenses, wildlife offenses, environmental offenses, etc., that the bill seeks to bring under the unlimited original jurisdiction of the court-martial is irrational. Unless these offenses have been assigned different definitions and ingredients, in which case Parliament will be legislating for a completely new offense, the minority finds no mischief at all in the proposal. In Uganda, if I may elaborate, we have only one offense called murder. There is no first-degree murder, second-degree murder, or third-degree. So the point I'm saying, the offense of murder is already provided for, unless the army wants us to provide for a different set of the murder. Take an example, Madam Speaker, of the offense of murder under Penal Code Act. All that is required is, one, that there is death of a person, a human being. Two, it is unlawfully caused by another person. And three, that the person causing death had malice or intention to kill. Where is the exceptional circumstance in the above offense of murder to warrant a trial before a court martial? Where is the exceptional circumstance in the trial of murder to warrant the movement from the civilian courts? That's the question I'm asking. It is therefore very confusing in the understanding what constitutes an offense of murder in a different way than what is provided already in the Penal Code Act. Right, Honorable Speaker, in 2020, at the height of the COVID-19 pandemic, the President wrote a letter accusing members of Parliament of attempted murder when the MPs sought to partake of the COVID bonanza by smuggling 10 billion shillings, which was paid to each MP at 20 million to isolate themselves from the COVID-19 in the lockdown. This points to the fact that there seems to be an understanding by different people of what murder and attempted murder means. And we must be careful to fight for that. The finding. The provisions of the bill on the courts martial falls acutely short of the standards required for fair trials and impartiality envisaged under Article 128 and 128 of the Constitution of the Republic of Uganda and the judgment of Honorable the Chief Justice Alphonse C. Owindolo. Conclusions and recommendations. Madam Speaker, the Uganda People's Defense Forces belongs to all Ugandans. It is a people's army which must not deviate from the aspirations, trust, and respect of the people of Uganda, which is well documented in the report to the Constituent Assembly. And those views, aspirations, were reduced into the provisions of the Constitution of the Republic of Uganda. The UPDF Amendment Bill 2025 is an extremely important bill in as far as, one, provision for the alignment of command, control, and administration, welfare of the officers and the militants, management of the military veterans, management of pensions, gratuities, and compensations of disabilities. The provisions, Right Honorable Speaker, for courts martial in the current substance and form as proposed in the bill are not properly well thought out, they are misconstrued, and are extremely dangerous for Uganda, as it seeks to undermine the aspirations of Ugandans as expressed wholly in the Constitution of the Republic of Uganda. Parliament should not allow it to be exploited into being accomplices in overthrowing the constitutional order of Uganda by creating a superior fourth arm of government, the courts martial, which will take over all criminal justice and leave the judiciary with only civil cases. The minority makes the following recommendations to Parliament on the Uganda People's Defense Forces Amendment Bill 2025. 1. That Parliament restricts consideration and the passing of clauses 1. I read. Parliament restricts consideration and the passing of clauses to clauses 1 to 28, clauses 76 and 80 of the bill which are touching the remedies A, B, C, D, and E, which I've already told you about welfare and etc. of the army. 2, Parliament severs, meaning Parliament severs and refers all clauses 29 to 75, 77, 78, 81, and all the schedules thereto back to the executive to comply with the Constitution of the Republic of Uganda and the judgment of the Supreme Court in Constitutional Appeal number 2 of 2021, the Attorney General versus Michael A. Kabaziguruka, and the live reference cases which are right now before the East African Courts of Justice and the Supreme Court of Uganda. 3, that Parliament requires government to table before Parliament the UPDF establishment, which is a regulation made under the UPDF Act for scrutiny to test its conformity to the UPDF Act. The reason is because this entire bill is premised on that document, which we don't have, distributing power, command, and what should happen. So the recommendation is Parliament requires, by whatever mechanisms available, the government to table that UPDF establishment, which is a statutory instrument, it's a regulation, which is made to come here, even if it is not, but it can be enforced. 4, Parliament proposes to the executive to provide all the necessary support to the justice chain actors, that is the police, office of the DPP, and the judiciary so that they can expeditiously dispose of all criminal cases. Recommendation number 5, that Parliament proposes to government to make special arrangements to facilitate the convening of special court session, could be High Court or Magistrates Court, depending on the jurisdiction, for purposes of disposing of all the cases ordered by the Supreme Court to be transferred from the courts martial to the civilian courts. Even if it requires the supplementary budget or something, the judges are there, the ODPP is there, the police are there. Give them money so that they can dispose of these cases. 6, Parliament proposes to the executive to respect the rights and freedoms of all Ugandans as enshrined in the Constitution, including rights to belong to political parties of their choices. 7, recruit, this is if we are inclined, this recommendation number 7, if we think civilians could be tried, this is the proposal. Recruit and train all Ugandans into the military. Arm them with all the items that are a monopoly of the UPDF. And then introduce a law which would then allow every Ugandan to be tried in the courts martial. There, we would have known the guidance of what you should do or not to do in the army. So that when all Ugandans are soldiers and are army, you can then try them. Without prejudice, Madam Speaker, to the recommendations proposed above, should Parliament insist on proceeding on the bill, the minority shall propose amendments to clauses 29, 30, 31, 35, 38, 45, 57, 63, and Schedules 7A and B. Right Honourable Speaker, it is trusted that this Parliament is appointed for the welfare of society and the just government of humanity. And we, the servants who are here assembled right now, are being looked upon with abundant flavor to perform such an important trust of Ugandans. Do not betray that trust. I beg to submit, Madam Speaker.
Thank you.